So the Supreme Court today is going to hear a petition against the new criminal laws. So recently new criminal laws were brought in to replace the old British era criminal laws. Not just in fact criminal laws, but Indian Penal Code, the IPC, of course the criminal laws. In addition to that, the Evidence Act as well. Okay. So all these laws, we'll see which laws are those, which laws they have actually replaced, and at the same time what's the reason for someone to file a plea against that, as well as the features of this law. We will be seeing all that. Okay, so having said that, let's get started. And remember, this hearing is going to start today as we speak. Now, what is the concern? What was the concern with respect to these laws that we are talking about? The concern was the pleader has basically said that when these laws were passed in the parliament, the parliamentary debate or discussion on these laws did not take place properly because a lot of the opposition leaders, not leaders, I would say the opposition members in the parliament were suspended. So since they were suspended, even though whatever small amount of discussion might have happened may not be fruitful, so it is as good as those discussions and debates not happening in the parliament. So that is the first point, that laws were enacted without any parliamentary debate. Why? The reason being opposition members were under suspension. That is one thing. Secondly, the plea also seeks the direction from the Supreme Court to constitute a committee in order to look into these laws. So talking about constitution of an expert committee that will assess the viability of the new laws, whether they are viable or not, what are the issues in that, right, so on and so forth. So these are the two things which the pleader has requested the Supreme Court, and the hearing will take place today. Now, which are these new criminal laws? The very first one, the Bharatiya Nyaya Sanhita, to replace the Indian Penal Code. So we had the IPC. All these laws are the British era laws. So the IPC, that is Indian Penal Code, is replaced by these bills have already been passed. So these are now laws and they have already replaced the earlier ones. So this is the Bharatiya Nyaya Sanhita. Second one, the Bharatiya Nagrik Suraksha Sanhita, which has replaced the Code of Criminal Procedure, or as we popularly call it, the CRPC. That is the Criminal Procedure Code. The third one is the Bharatiya Sakshya Adhiniyam. Adhiniyam means again law. Adhiniyam means law. Sakshya means evidence. So what has it replaced? It has replaced the Indian Evidence Act of 1872. Right. Now, they have become the law, and they are to be coming to force from July 1st, 2024. Now, remember, see, these names are generally Hindi names. So, someone who would know Hindi would understand the translation also. So, if you are not understanding, please remember it so that it helps. Because, for example, Sakshya Adhiniyam. So, if you don't understand, maybe, sort of, I can say it becomes easier for someone who understands Hindi, but not a problem. The same thing happens when certain other words are there, but in government schemes and government laws, it's majorly the Hindi terminologies that are used. So, we need to make that effort to ensure that we know them. Okay. So, Sakshya matlab, kisi cheez ki sakshi dena. To give, let's say, evidence for something. So Sakshya means evidence, Adhiniyam means law, Bharatiya means Indian. So basically this is the Indians Evidence Act that we are talking about. Okay, so these three are the new laws which has replaced the earlier ones. Now, having said that, let us now look at each and every law and see what are the sort of important additional provisions which they are bringing. Now remember, the names have changed. But also you should remember the laws have completely not been replaced. Let's say if this is a 500-page book of Evidence Act, it is not replaced by another 500-page of book. What has happened is a lot of things have been kept unchanged. It has been kept the same. But whatever certain things which were not required would be eliminated. That is actually less. More what has happened is certain things have been added. Now what is the reason for adding that? See, these laws made in 1870s and all that, it's over 100 years ago, 200 years ago. So the thing is, lot of things were not present there. which needs to be incorporated. Now these were amended previously, but now they have been completely replaced. For example, digital evidence, right? 200 years ago, digital evidence was not there. Even till recently, digital evidence were not all the time in every format permissible, but that now has changed. So now we'll see what things have changed. So the Bharatiya Nyaya Sanhita, which replaces the IPC, Indian Penal Code, which law is replacing, which is very important, especially for your prelims. So what it has done is it has incorporated new offenses. What are the new offenses? Offenses like the organized crime, terrorism, and group act of hurting or killing someone, that is mob lynching. Mob lynching have been added. So if we look at this, organized crime, terrorism, and group related grievous hurt or murder. Group related grievous hurt or murder is mob lynching, what we are talking about. Okay, that has been added. It also till this time, you know, if you look at some Hollywood movies or series, you will see when someone is punished for something, all the time they will not be behind bars. Sometimes they will just be asked to do some social service, community service, and let go of under certain charges. Now that provision as such was not present in India in the IPC. Now they have included that provision, that is added community service as a form of punishment. And actually that is a very practical way to do it. For example, let's say you break a signal. Okay, you break a signal. Now you break a signal, you are caught, you paid 1,000 rupees, 2,000 rupees, and it doesn't much matter to you, you don't care about it. Next time you still break it, you have the money, you do it. But if you are made to do community service, right, instead, so then you will have to give your time to community service, right? You need to take out time and do the community service for one day. Let's say, for example, you are made to take care of the traffic of a particular place, or to, you know, go somewhere, do some social activity, social work, give your time, effort, and service to the community. Now that is a good way, because that would deter people, that is one thing. If not, that thing could be utilized for the welfare of the society. At the same time, certain times, instead of putting someone behind the bars, they are asked to do community service. So community service is a good way or a good addition to this particular law. Next is the sexual offenses against women. So what about this? It has raised the age threshold of gang rape victim from 16 to 18 years. Now this is very important. At times if you look at it, you will think why it was 16 before, it should have already been 18. What do we mean by this? See, for the victims age 16 less than equal to 16 were considered as minor, and more than 16 were considered as adult. Now that threshold has been increased from 16 to 18. Now less than equal to 18 also will be considered as minor. Alright, so this is again a good addition or a good amendment that has happened. Additionally, it criminalizes deceptive sexual acts or false promises. What do we mean by that? Sexual act which is done after deceiving someone else. Let's say impersonating. Someone met someone on, let's say, online, but now instead of that person, someone else has gone and met and have sexual encounter. So that is out of deception. So if that is the kind of deception, or for example, false promises. False promises is, for example, promise of marrying them in the future. So if under these circumstances the sexual encounter or sexual acts were done, they are criminalized, they would be punishable. Also, it excludes adultery as an offense. So adultery was considered an offense, but recent Supreme Court judgments has now decriminalized adultery. So following on the footsteps of the decision of the Supreme Court, this act also excludes adultery as an offense. Now it is a sort of a dilemmatic thing probably, because adultery, someone would say, of course it's not, it should not be punished, but at the same time, what about the victim whose partner has done adultery, what they undergo through? So it could be probably a good mains question or an interview question, which is sort of a dilemma. Now many people would have a very straightforward answer to this either way, but since people would be divided on it, that is why it would be a dilemmatic problem. But you should remember that it has excluded adultery as an offense. Now coming on to the Bharatiya Nagrik Suraksha Sanhita that has replaced the CRPC, let's see what are all the things. Now what they have done is they have mandated forensic investigation, okay, for which crimes which are punishable by at least 7 years imprisonment. They have mandated it. It is necessary for the investigation party to do forensic investigation. What is forensic investigation? Forensic investigation of the crime scene and the scene's related place related to that activity. So scientific investigation, you collect various samples, you make tests and identify the presence of DNA, fingerprints, all those things in a forensic, in a scientific manner. It has been mandated for crimes punishable by at least 7 years of imprisonment. Remember, any crime punishable 7 years or above, it is mandatory. For crimes below 7 years, you may or you may not do it. It is not that it is barred or prohibited. You can still do it, but it is not mandatory. But for crimes punishable by at least 7 years of imprisonment, it is mandatory, because doing forensic investigation would help to get better results. Okay. Now when it comes to sample collection, it has extended the power to collect finger impressions, even voice samples from individuals who are not under arrest. What do we mean by that? See, what happens is generally, let's say if you are arrested, when you are arrested, definitely they will take your fingerprints for the record. Once you are arrested, when they arrest you and they are about to put you behind bars, before putting you inside the jail, they will take your fingerprints, thumb impression and everything, impression of all the fingers in fact, and then put you behind the bars. Now this power has been extended for taking fingerprints of even those people who are not arrested. Let's say you are brought in for questioning, okay, but you are not you, of course, someone, let's say take an imaginary person brought in for questioning. There is no arrest warrant, they would not be arrested, but still there is power given to take their fingerprints, not just fingerprints, also the voice sample. Now why is that being done? Because then that will be added in the record, and next time if something happens and in a crime scene the fingerprint matches, point number one, who is the person, and that for something else also that person was brought for questioning, so you may be able to connect the dots, right? So it would give a better knowledge base or record base for the investigation teams to do their investigation. Okay, so for individuals who are not under arrest, their samples will also be taken. Okay, now the Bharatiya Nagrik Suraksha Sanhita, it's the same thing which is going on. Timeline. When it comes to timeline, the timeline basically the issue with the timeline is that they are too wide. Too much time is being taken to, let's say, finish off a case, to give a judgment. Now with respect to that, for the crimes of rape, what has happened? Medical report for rape victims within 7 days it has to come. There is a time limit, boss, you cannot delay it. Fine, 7 days. Judgments within 30 days, which is extendable to 45 days. Under certain circumstances, it can extend, so it is extendable to 45 days. Now, victim progress updates within 90 days. What about the victim? The benefits that is going to the victim, whether that has been received or not, so on and so forth. As well as the charge framing within 60 days from the first hearing. What is charge framing? Charge framing is when there is an allegation on a person and there are certain evidences to support it, then the charges will be framed. Charges framing need not necessarily mean that the judgment has been given against the alleged person and is about to be put behind bars, but charge framing means that if found guilty, what all under what all charges that person will go to jail. That is what framing of charges is, which should be done within 60 days from the first hearing. Now comes the this is the same thing, Bharatiya. This now comes the Bharatiya. It should not be Bharatiya Nyaya Samhita. It should be this one, Bharatiya Sakshya. The third one, which is the third one, Bharatiya Sakshya Adhiniyam. Bharatiya Sakshya Adhiniyam. Okay, this should be Bharatiya Sakshya Adhiniyam. Adhiniyam means act. Which has replaced the Indian Evidence Act of 1872. So what it talks about, it broadens the definition of documents that can be included as evidence, right? So what all it is including? Electronic records, the traditional paper, documents, receipts, all those were taken into account as evidence, but now it adds the electronic records as well. Okay, now also it has further division into primary evidence and secondary evidence. So primary evidence, of course, whatever it was, it has retained in the primary evidence, that is the documents. It has added, as I said, the electronic records, and video recordings have also been added. Now when it comes to oral and written admission along with testimony from a qualified individual examining the documents are now considered secondary evidence. I'll explain what does this mean. Oral and written admission along with testimony from a qualified individual. See, primary evidence is clear. Whatever was there previously, it is there now also. The documents, the receipts, the written, everything in the form hard copy, as well as electronic records and video recordings, even they are now primary evidence. What is secondary evidence? Secondary evidence is, for example, let's say there have been a crime which was committed and there is a plea from the alleged person whose lawyer is saying that this person acted in a fit of insanity. So generally what the perpetrator pleads is that crime happened due to insanity. Okay, let's take for example, that person has killed someone or did something, hurt someone, and now they are claiming that it happened out of insanity, the person lost their mind. So to understand whether the mind was actually lost or not, the court may put a psychiatrist who is a specialist in not reading the mind but understanding the psychology. And then that person would interview this particular person, look at the historical record, the background, the family background, the upbringing, everything, and then either orally or in written form along with a testimony give their judgment. So these are what? These are qualified individuals, experts who will examine the document or the person and then give you, or let's say if you are examining the handwriting of someone, whether it's the same handwriting or not, right? So that specialist will be doing that and then giving the result output of their analysis along with a testimony. That is considered as secondary evidence. Okay. Now, oral evidence. What is oral evidence? Now, oral evidence in the form of electronic audio is also permitted. So, permits electronic provision of oral evidence. What do we mean by that? Instead of being present in the court, on the call, on the video call, the oral evidence in an electronic form can also be given, right? Enabling witnesses, accused individuals and victims to testify through electronic means. You can testify through a video call also in the court. That is possible, right? Because the use of technology is now increasing. These things are there. Now, for example, even when you have to take a pension, let's say you are going to take a pension for your father, grandfather to the bank, every time you need not take them also. You can go fill the form, along with their passbook, give your Aadhaar card and just make a video call with the bank representative and you will get the pension. In the same manner, over here also, the witness can testify electronically as well. Now, admissibility of electronic records. Now, electronic or digital records have been granted equivalent legal status as paper records. So, earlier paper records were there, electronic or digital records were not given, let's say, that legal status, right? You can still show to the police and all that these are the electronic records, etc., the chats, whatever, but there was no legal backing. Now there is a legal backing and it is given equivalent status as well. What does it include? It includes the information that is stored in the chips, in the smartphones, in the laptops, right? Even if your laptop and all is not working, still the chip will have the information and that can be retrieved. So even that is considered to be having an equivalent legal status. All right. So these are the features of the 3 new laws that have been brought in. Now the plea is about that they were brought in without any parliamentary debate, and also that a proper committee needs to be formed to analyze their viability. Now when the judgment comes out or whatever developments are there, whatever criticism of these things and other things happen, that will be updated and you will be updated with respect to that. So keep watching Legacy IAS YouTube channel. Thank you.